Cultural and educational rights. Article 29. Protection of interest of minorities. This provision of the Constitution aims to protect the interest of minority groups. Article 29(1). This provision states that any section of the citizens residing in India having a distinct culture, language, or script have the right to conserve their culture, language, and script. Article 29(2). This provision mentions that the state must not deny admission into educational institutes maintained by it or those that receive aid from it to any person based on the grounds of race, religion, caste, language, or any of them. Article 30. Right of minorities to establish and administer educational institutions. This right is provided to minorities to form and govern their own educational institutions. This is why the said provision is also known as the Charter of Educational Rights. Article 31. 30 Division 1. This provision states that all religious and linguistic minorities have the right to establish and administer educational institution of their choice. Article 30 Part 2. This provision provides that the state, when granting aid to educational institution, shall not discriminate against any educational institution based on the reason that it is under the management of a minority, whether based on religion or language. Article 32. Right to constitutional remedies. The Constitution guarantees certain remedies if the fundamental rights of citizens are violated. The state does not have the power or authority to infringe upon or curb the right of any individuals. In case these rights are violated, the aggrieved individual can approach the courts. They can even directly approach the Supreme Court of India, which can issue writs for the enforcement of fundamental rights. There are 5 kinds of writs that can be issued by the court. They are: first, habeas corpus. The term habeas corpus means to have the body of. As per this writ, the court has the authority to call upon any person who is being detained to assess the legality of their detention. Certiorari. The term certiorari means to be certified. By the virtue of this writ, a higher court reviews a case that has been tried in a lower court. It is basically employed to seek judicial review of a decision given by the court or a government authority. Prohibition. The writ of prohibition is issued by the court to restrict or prohibit the lower courts, tribunals, and other such quasi-judicial authorities from acting beyond their legal authority. It is employed to check inactivity, whereas the writ of mandamus checks activity. Mandamus. The term mandamus means we command. This writ is employed by the court to direct a public official who has failed or refused to do his duty to resume his work. The writ of mandamus is also issued against a public body, an inferior court, a corporation, a tribunal, or a government. Quo warranto. The term quo warranto means by what authority or warrant. The Supreme Court or a High Court employ this writ to avoid illegal usurpation of public office by an individual. The writ of quo warranto authorizes the court to examine the legality of a person's claim to a public officer.